Okay, let me first start by introducing myself. Some of you already know me. I introduced myself. My name is Nick Montalto. I'm a lawyer here on Staten Island, and I'm also a CPA, a certified public accountant. I've been a lawyer for about over 40 years. Before practicing law, I was in the corporate field. I was the vice president and general counsel of a big advertising company. I was a manager at KPMG, Pete Mahler. And then I went to law school, became an attorney, and for the last 30-odd years, I've been practicing law. My practice has been in almost every area of law. I've tried trial work, tried cases, I've done corporate work. Pretty much you name it, I've done it. The last 10 years or so, I've kind of limited my practice pretty much to elderlaw and estate planning. And my purpose tonight is to basically give all of you a little information about what estate planning is, what elderlaw is, so that at least you have some information and you can make decisions for yourself. I'm not here to sell myself, to sell you anything, sell you my services. If you all have attorneys, that's great. Whatever I say, you might want to discuss it with them. Okay, if you want to discuss it with me, that's fine too. I say that because I know there are a lot of seminars that go on, and unfortunately, sometimes attorneys try to sell products or things like that. I'm not here for any of that. Okay, so we have a small setting, so let's try to keep it informal. Now, I gave everybody a little handout, which is basically just a rough outline of what I hope to talk about. Now, first of all, estate planning, just the word, basically all it really is a plan that we make up so that when we die, however we want things to happen, they happen. While we're alive, if we get sick or we're disabled, things go the way we wish them to go. So let's start with basic estate planning needs. There are certain documents that everybody has to have, everybody should have. And those documents are basically a will, a durable power of attorney, a living will, and a healthcare proxy. And I'm going to try to explain all of those, what they are. So let's first start by talking about a will. Now, we talk about a will and what happens when we die. There are a lot of misconceptions. And some of what I'm going to read are things that I hear from people that call my office. A lot of people think, well, if I die, everything's going to go to my wife. A lot of people think, whatever I write in my will, it doesn't matter what anything else says. Whatever my will says, that's what's going to happen. That isn't necessarily true, and I'll explain in a while why. A lot of people think, I really don't need a will. I'll just write it up, I'll get it notarized, and that's it. A lot of people think in order to make up a will, I could just write it out, get it notarized, and list everything I have in the will. Again, that's not true. People also sometimes think, I gotta leave all my kids at least $1. I have to leave my wife so much, things like that. So let's start from the top. First of all, a will is simply a piece of paper, a legal document that has certain formalities. It's a document made up which basically says that when I die, this is who I want to get my property, and it lists who they are. Now, under the law, you don't have to leave your children anything at all. You don't have to leave them $1, you don't have to leave them anything. The only person you must leave property to is your wife or your husband if you're married. And under the law, you have to leave them at least 50% of whatever all your property is. Now, if you don't leave them 50% and you cut them out, they have the right, when you pass on, to go to court, and the court will automatically give them 50%. Now, of course, like anything else, what I'm saying, there are exceptions to this. Sometimes people get married and they have things called prenuptial agreements. Many times in second marriages or marriages late in life, the people may decide, you know what, I want to be able to leave everything to my kids, or the wife, I want to leave it to my kids, and they sign a paper saying that they could do that. But unless there is something like that, under the law, the wife or the husband automatically gets a half. Now, if you don't have a will, what happens? Well, if you don't have a will and you die, your property goes according to the law. The law spells out exactly who gets what. So let's take it from the top. Let's assume you don't have a will and you die. Well, the law says that your wife's going to get half. Actually, your wife gets $50,000 plus half of everything you have. and the rest of it is divided between your children. If you don't have a wife and you only have children, everything goes to your children equally. If you don't have a wife and you don't have children, then it goes to your brothers and sisters. If you don't have brothers and sisters, it goes to your nieces and nephews. Don't have nieces and nephews, then it goes to cousins. If you don't have cousins, then it goes to the state, and that's what happens. So many times, if you don't have a will, property is going to go in a way that you don't necessarily want it to go. So that's why, for the most part, people should always have a will. Now, a will not only says how people are going to get your property. When I say property, I don't necessarily mean a house, I mean anything you own. A will also lets you specify who's going to take care of little children, assuming you have minor children, if you pass on. So if you pass on, you have children, the little ones, who's going to be their guardians? And a will lets you specify who it is. Basically, a will will say that if I pass on and my children are under 18, my brother or whoever you say is going to be their guardian. If you don't have that in a will, then the court's going to decide who that person's going to be. And that may not be what you want. So it's very important for everybody to have a will. It doesn't matter whether you have $1 or $1 million. Unless you have a will, somebody else is going to make decisions that you don't necessarily want. Now, people make up wills, and only an original will is signed. And I have this all the time. People come in, so-and-so died, and they have a copy of a will. Copies of wills are meaningless. If you lose the original, you don't have a will. Nothing will replace it. And I say that to people all the time because I make up wills and people ask for copies, and I try to say all the time, only the original counts. And the reason for this is simple. When you sign the original will, let's assume you change your mind. You don't want your will. All you do is rip it up. So under the law says, well, if we can't find your original will, we're going to figure that whoever made it up didn't want it and he ripped it up. Okay, so I just passed that out to everybody so that they know. A will is fairly simple. It doesn't list all your property. A will may say something like, if I die, I want my wife to get everything that I own. If my wife dies before me, or the two of us die together in an accident, then I want it to all go to my children equally. The will also say who's going to be in charge of this. The person in charge is called an executor. So the will say I appoint my wife as the executor. If my wife dies before me, then I appoint one of my children as the executor. It's as simple as that. It doesn't have to list what you own. Many times a will say, I leave everything to my wife. If my wife dies, I have 3 children. I give child 1 20%, child 2 60%, the other child the balance. It could be any formula that you want. Okay, so that's pretty simple. If I have any questions, rather than wait till the end as I'm going along and you want to ask, just raise your hand and we can answer them. So hopefully that's clear on what a will is. Now, the next thing besides a will is something called a durable power of attorney. Now, a power of attorney is basically a piece of paper that lets someone else do what you could do. Now, there are a lot of misconceptions about powers of attorney. And again, what I'm saying are stories that I hear and people that have come to my office over the years. Sometimes people say, I don't need a power of attorney. My son and my daughter's on all my bank accounts, so I don't need that. Or sometimes they say, well, everything is in both our names, so we don't need a power of attorney. A lot of times, people are afraid to make a power of attorney because they think, well, if I do, that means that whoever I give it to, they're going to run my life, they're going to decide what I'm going to have and what I'm not going to have. It doesn't really work that way. Here's how a power of attorney works, and I'm going to have to use an example. Let's assume that someone lives by themselves, a widow or a widower. And that person has a stroke and is unable to carry on his affairs. And that person needs, let's assume, health care. Well, one of the things we'll get to later is, if that person's house is in his name, it's got to be taken out of his name. So in order to do that, the only person that could do that would be him. If he's unable to sign his name to get the house out of his name, it can only be then done by the courts. And that involves the courts appointing guardians, and it gets very, very expensive. If instead that person had a power of attorney saying his son can sign his name in the event he couldn't, it's real simple. The power of attorney lets him sign his name, and transfer his property. And I use that just as a simple example. But without a power of attorney, if you're unable to sign your name for any reason, then the courts are going to decide who's going to handle your affairs, who's going to be your guardian. So again, like the will, you make up the will, you decide how things are going to be. Same thing with a power of attorney. If you don't have one, the court's going to decide who's in charge of you. The next thing we're going to talk about is a living will and a healthcare proxy. Now they kind of go hand in hand. Let me try to explain each one. Some misconceptions. Sometimes people think, well, if I get sick, my wife can make any decisions if I go to the hospital. Or sometimes people tell me, I already have one, I signed a paper at the hospital. Other people say, I don't want one of those because if I sign one of those, they're going to pull the plug on me. None of those things are true. First of all, the purpose of there's two parts. A living will is a paper that you sign that basically says, in legal terms, if I get sick and I can't make decisions, and I'm in a condition where I'm not going to get better, I'm going to be brain dead, I don't want to be kept alive artificially. I don't want to have feeding tubes, I don't want to have this, or I don't want to have that. And if I can't make those decisions because I'm physically unable, I'm designating someone else to make them for me. So the first part is the living will. The healthcare proxy is saying, if I can't make it, my son or my wife or whoever it is can make it for me. That doesn't mean that whoever I give it to can do whatever they want. They have to do whatever I said in my living will. Now, many times people may decide, well, if this happens, I do want a feeding tube, I do want this. Well, whatever it is, that person has to honor your wishes, and he's able to do so with the healthcare proxy. If you don't have that, unfortunately what then happens is the hospital makes decisions for you, which may or may not be what you want. We all probably remember those cases with Karen Ann Quinlan, and they kept these people alive for no good reason forever and ever. Well, those all happened because there was no one that was authorized to make those decisions for them. So again, that's the purpose of a living will and a healthcare proxy, okay? It lets you say what kind of treatment I'm going to get, and if I can't decide, if I can't make the decision, someone else can. Now, when you sign one of these and you're in the hospital, it doesn't mean that your wife or your husband or whoever can make decisions. If you're able to talk, you're the one who makes decisions. It's just when you're unconscious and you can't, and someone says, well, he's not going to get better. He's not expected to live more than a week. What do you want to do? Do you want to put him on a respirator? Do you want to do this, that, and the other thing? That enables that person to do that. Without that, the hospital is going to decide, and 9 chances out of 10, they're going to do all the extraordinary measures to keep you alive as long as they can. And in many situations, that isn't what you want. So those are the 4 basic papers that everybody should have. The will, the durable power of attorney, the healthcare proxy, and the living will. Now, one of the questions that sometimes comes up is what are fees? Many lawyers go to seminars, they'll say, well, I can't tell you the fee, I'll let you know when you come in. I'm not like that, I'm above board. This is what the fee is. For a husband and wife to have all those documents that I just described, the will, the healthcare proxy, the living will, power of attorney, it's $500 for both of them. Or if there's only a husband, it's $250, the other is $250. People say, why are your fees so low? Because I choose them to be low. I try to be fair, okay? God's been good to me. Frankly, I'm very grateful. I don't try to bleed people, I try to be honest with people, but on the other hand, I have to be compensated as well. So that's my fee for that, okay? And that settles that part. Now, the next question that sometimes comes up, what people ask me is, well, if I die, what about taxes, okay? Do I have to pay income taxes? Do I have to pay, what do I have to pay when I inherit money? First of all, there are no income taxes when someone dies and the person inherits money. So if someone died and they had $1 million and they left it all to you, you don't pay any taxes on that $1 million. However, the estate, the person that died, may have to pay estate taxes. Now, the laws have been recently changed, and there are 2 estate taxes. There's a federal and there's a New York estate tax. Right now, under the federal estate tax law, there's an exemption of $5 million for a husband and $5 million for a wife. So as a practical matter, for most people, there would be no estate tax unless it was over $10 million. Now, New York, the state of New York, has an inheritance tax, which has an exemption of $1 million for each person. But whatever a husband leaves to the wife or vice versa, there is no estate tax. So depending on someone's circumstances, there possibly could be a New York estate tax if you were leaving more than $2 million to someone other than your wife. And again, there are ways to minimize those taxes as well, which we're not going to talk about tonight, but I just want to give you some general information so you know the story about what estate taxes are. So before I continue, any questions at all about anything I've said so far? Okay, I'm trying to keep it simple. Now, besides all of these documents, some of us may have heard the word trust, talk about estates and trusts, and what's a trust? Okay, a trust is simply an agreement where I give you my ring. I say, listen, hold my ring. When I die, give my ring to my son. I'm trusting you to hold my ring and do what I say when I die. That's the concept of a trust. I take some property. It could be a house. It could be an article of jewelry. It could be a stock. And I say, I'm giving you this stock, not for you to keep, to hold in a trust. And when I pass away, this is what I want you to do with it. That's essentially what a trust is. And this is done by a legal agreement that you set up saying, I'm setting up the trust, I'm putting my house in the trust, or my stocks in the trust, whatever it might be, and this is how I want it distributed. The person you designate to be in charge, the trustee, signs the paper and agrees to do it. So it's a legally binding agreement. When you pass away, it's not up to him to then take it and keep it for himself. So that's the concept of a trust. Now, there are many different kinds of trusts. So I'm just going to try to talk about some of the more common ones. First of all, there are trusts that are called revocable trusts and irrevocable trusts. These are the differences. A revocable trust basically says, I'm going to take my house and I'm going to put it in a trust. When I die, I want my house sold and divided between everybody. This trust is revocable. What does that mean? It means that's what I'm doing today, but I could change my mind tomorrow and revoke it. I now own my house back. It's in my name, and that's the end of it. What is the advantage of a revocable trust? Well, the advantage is, to some extent, if you died and everything was in a trust, you really don't need a will because everything is going to go the way you said in a trust. Now, unfortunately, you'll see a lot of ads that talk about avoid probate, put your property in a revocable trust. That is, in my opinion, very foolish advice. Avoiding probate is not a problem. Probate in the state of New York is very simple, and it's not inordinately expensive. Probate, all the war stories we hear about probates are in certain states, like California, that has very, very high probate fees. So as a result, they advertise or they tout that everybody should have a trust to avoid probate. The disadvantages of setting up a trust is they're expensive. Okay, they're not cheap. Unlike the cost for wills, trusts go into the thousands. And they don't really, a revocable trust doesn't really protect anything. All it does is, quote, avoids probate. But let's assume you had a house and you put your house in a trust. But now you have bank accounts that are not in a trust. Well, you still need a will in order to decide who's going to get your house. So it is not a solution, in my opinion, to any problem, a revocable trust. And I'm only mentioning it so everybody knows what it is. Now, an irrevocable trust is a different story. An irrevocable trust, which I'll talk about in a little while, is basically the same with one big exception. Once you do it, you can't change it. It's irrevocable. And that's usually used to protect your property in the event you get sick, God forbid you have to go to a nursing home, or you need health care, or things like that. Now, the next kind of trust is something called a special needs trust. Now, how does that come about? Well, I've heard people say, oh, I have a disabled son. He gets SSI. So I can't really leave him anything. So what I'm going to do is I'm leaving it all to my daughter, and don't worry, I know she'll take care of him. Okay, famous last words. Well, now, the real thing, most parents want to make sure that both the kids get the benefit of it. So how do they do it? There's something called a special needs trust. which the law approves and the government approves, which basically lets you set up a trust for a disabled child that's getting government benefits, and he doesn't lose those benefits. The money you put in the trust can be used to supplement his needs, which means to help him have a better life, however the trustee decides to use it. So it enables you to provide for someone disabled and at the same time that person not lose their benefits. So that's what's called a special needs trust. The next kind of trust is a spendthrift trust. Now, had people come in and say, you know, I have 2 kids, they're both great. I really want to treat them equally, but you know what? My son's got a drug problem. He's good today, but God knows what he's going to do tomorrow. If I leave it all to him, he may blow it all. So I'm going to leave it to my other son, and he'll take care of it. Okay, that's not going to happen, or it may not happen. So the question is, how do I leave money to a child who isn't good with money, may blow it, and at the same time, I want to treat him fairly? Well, that's done with a trust called a spendthrift trust. And the way that basically works is child number 1 gets his share of whatever it is, he gets his half. The other child, we'll call the problem child, his money goes into a trust. And you appoint someone who's then going to decide, dole out his money in a way that he's making sure he's getting his money, still his, but he's not blowing it. So let's assume that child had $100,000 in the trust fund. Well, he's not going to be able to ask the trustee, you know what, I want $80,000, I'm going to do some bizarre thing. The trustee, whoever you appoint, would obviously be telling him no. So it's a safeguard. On the same token, the money in that trust can't be used for anyone other than him. So it's kind of a monitor on his money, a way of protecting his inheritance. And that's basically a spendthrift trust. Now, the last kind of trust I'm going to talk about is something called a bloodline trust, and that's kind of recent. And this is the way this scenario works. I've had people come in and they go, you know what, I'm leaving everything to my son, but I can't stand his wife. My biggest fear is if he dies, that blah, blah, blah is going to get his money, she's going to get remarried, it's going to go. I don't want her to have it. I want my grandchildren to have it. How do I do it? And there is a way of doing it. And that's another kind of trust, which is called a bloodline trust. And the way that works is basically this way. Let's assume we have 2 children. We leave their shares in a trust. The trust is going to say that so-and-so is the trustee of it, and all the money's theirs. Whatever they want, they could take out as they need it. When they die and when they're gone, whatever's left in that trust doesn't go to the wife, goes to my grandchildren. So by doing this, with this kind of trust, the daughter-in-law or son-in-law, as the case may be, isn't getting your money. That money, whatever's left, is going to go to your grandchildren. And that's what's called this bloodline trust. So that's kind of it in terms of wills and estates and trusts. Any questions up to this point? Okay, now we'll move on to the subject of elderlaw. Now, oh, I'm sorry, yeah?
If you have a will that states what you just said,
Right.
you know, you wouldn't need the trust then, would you?
No, that's right.
The will states that.
What I'm describing when I talk about a bloodline trust, these are trusts that are written into a will.
Okay.
Okay? It's not a separate paper. This is something written into the will.
Okay.
So your will, for instance, let's assume would say, if I die, everything goes to my wife. If my wife dies before me, it goes to my 2 children. But my 2 children aren't to get the money outright. Their share is going to go into a trust, and so is going to be the trustee. Whatever he feels that they need, he will give them. If my child dies and there's money left in that trust, it goes to my grandchildren. So that means that the daughter-in-law or son-in-law, as the case may be, has no claim on that money. Okay, so it's written into a will. Now, one of the subjects I forgot to mention before is I said, if you have a will, the will does not override everything you did. Sometimes people make up a will and it isn't going to do what they want. Let me explain. If you have a bank account, and on your bank account, you have $100,000, and the bank account says it's in trust for your daughter. And then in your will, you say, I have 3 kids, I want them all to get it equally. Well, that will not pass any of the property in that bank account, because that bank account is named the daughter as the beneficiary. So the will is only going to pass property that's only in your name alone. So the daughter's going to get the $100,000 because her name's on the bank account, and the other children aren't going to share in that. Now, I'm using a bank account as an example, but it could be life insurance. You have a life insurance policy that was taken out years ago, and the beneficiary is maybe one of your children. And now you had more than one child, and they're not on the life insurance as a beneficiary. Well, they're not, even though you write in your will you want it equal, it's not going to matter. The beneficiary designation will override that. So, just something to keep in mind. Now, the next thing I started to mention is elder law. Elder law is no different than younger law, okay? It's only that as you get older, there are needs that older people have to deal with that you didn't have to deal with when you were young. And the biggest concern about most people is if I get sick and I wind up in a nursing home or I need home care, what's going to happen? They're going to take my house. It's going to cost me a fortune. What do I do? How do I pay for a nursing home? How do I pay for this? Well, obviously, you could pay for it yourself if you have the funds to do it, or if you have long-term care insurance, that might take care of it. But most people don't have enough money to pay nursing homes. Nursing homes today cost, over $12,000 a month. And long-term care insurance, depending on what age you buy it at, is very, very expensive. And most of the policies of long-term care don't really cover everything. There are a lot of limitations on it. So for most people, what they generally try to do is become eligible for Medicaid, to let Medicaid pay for this. Now let me back up. There's two government programs, Medicare and Medicaid. When you're 65, we all get Medicare. We don't get Medicaid. Medicare does not pay for nursing homes. Medicare does not pay for home health care. It only pays for rehabilitative care. So if you had an operation and you need some rehab for a month or so, and you're in a nursing home for rehab, it'll take care of that. But it does not take care of long-term home care, long-term nursing home, or long-term home care. The only program that does that is Medicaid. Now, Medicaid is a program run by the state, and every state has different rules. In order to get Medicaid to pay for nursing home care or home care, you basically have to be poor. You have to have very limited assets. You're only allowed to have less than $20,000 in assets, and if it's a husband and wife, you really can't have more than about $1,500 in income. So, what do people do to protect their property and still get Medicaid? Well, that's where the irrevocable trusts come in. Now, the irrevocable trust, as you remember, the only difference between that and the revocable is once you do it, you can't change it. Now, for most people, their real concern is their house. It's usually a major asset. So if someone gets sick and is going to wind up in a nursing home, or even if they're not in a nursing home, and today many people live out their years in their own house, and they have home care. Some of you may be familiar with it, where nurses and home aides come into the house to take care of people either on a living basis or so many hours a day. Now, both of those programs, okay, allow you to still have a house. They're not going to, quote, take your house. They're not going to force you to sell your house. But what they will do is they will tally how much your care has cost, whether it's in the nursing home or whether it's in your own house. And they will file a lien, which is like a mortgage against your house. So that when you pass away and your house is ready to be sold, if your house was worth $500,000, it may be, depending on how long you receive benefits, that you have liens owed to the state of $300,000 or $400,000. And worse than that, sometimes your house could have no value because of all the money that the state now wants to be repaid. So we'll go back to the question. So how do I protect my house? The way we protect the house is we take the house and we create a trust, an irrevocable trust. And what the trust is basically saying is, I am putting my house in a trust. However, there are some stipulations. The first stipulation is, while I'm alive, nobody could sell my house unless I say okay. When I'm gone, then my house can be sold and divided up however I say. Now, that's called an irrevocable trust or a Medicaid trust. Once you do that, you and then start receiving Medicaid, they can't do anything in terms of filing liens against your house or forcing a sale, because technically you don't own your house. You have the right to live there for the rest of your life and some other rights, but the house is owned by the trust. So that's the usual way that people protect their house. Now, sometimes people say to me, well, if I put my house in a trust, am I going to lose my senior citizens exemption or my veterans exemption for real estate taxes? And the answer is no. You don't lose any of those exemptions. You still have complete control of your house. If your son or your daughter is the trustee, they can't sell it unless you agree. If you decide, I put my house in a trust and now I want to buy another house, can you sell your house? The answer is yes. You could still sell your house. The new house you buy would not be in your name, but would be in the name of the trust and be under the same conditions that you originally set up. Now, besides having control by putting your home in a house, yep.
Just a quick question, how soon before you start receiving care does your house?
Yeah, I'm going to go through that in a second, okay? Now, besides the fact that you have what's called a life estate, which means your house can't be sold unless you say so, you also have some other things in the trust agreement that you could change. You name who your beneficiaries are. Let's assume it's your 3 children. You have the right at any time to decide, well, I want to eliminate one of my kids. Tick me off, I don't want to leave them anything, or I want to give this one more, or this one's less. You can always change that. What you can't do is say, I want to end the whole trust and put that house back in my name. That you can't do. So generally, the Medicaid Asset Protection Trust serves that purpose. Now the next thing we go to is, can I do this today and then go into a nursing home tomorrow and be home free? The answer to that is no. There's something called look-back periods. And here's the way that works. If I take my house and I'm using the house as an example, but it could apply to anything. I have to go into a nursing home tomorrow, so I take my house and I put it in a trust today, and then I go into a nursing home. Will that work? The answer is no. Because for nursing home care, there's what's called a 5-year look-back, which means if I transfer my house and put it in a trust and I have to go into a nursing home, there has to at least have been 5 years that passed from when I did it to when I got Medicaid for a nursing home. But the big advantage in New York is that that does not apply if instead of going to a nursing home, I want to stay in my own home. A person had a stroke and they need someone now to take care of them, and Medicaid has that program. There is no look back for that. So I could take my house, transfer it out of my, name, put it in a trust and get Medicaid tomorrow. My parents who were long gone, that's exactly what we had done for them. We took their house, we took it out of their name, we put it in a trust. For their 5 years before they died, they both had 24-hour home care, and the house was never in question. There was never any liens or anything else filed against it. So the 5-year look-back period does not apply for home care, but it does for nursing home care. So that's essentially it in terms of Medicaid and how to qualify for Medicaid. Now, what the information I'm giving you today is, I realize, somewhat general, because it's tough to get specific with everybody's particular situation, but I'm trying to at least educate everybody on some of the possibilities that exist. And each of them can be tailored to everybody's needs. Now, the last thing, because I really don't want to hide anything, is, well, what does all that cost? That is more expensive than the wills we talked about. To have a will, the health care, the power of attorney, all those documents, and also protect my house by having a trust, having my house transferred, a new deed has to be made, transferring my house into the trust, that is approximately $2,500 to do something like that. And again, I don't know if any of you are familiar, that fee is extremely reasonable. So that about concludes my remarks on what I said. Hopefully I've given you some information to think about for yourselves or others that you may know that need this information, and fire away if you have any questions.
Okay, can you put your house in a trust if you still have a mortgage on it?
Yes. If you have a mortgage, you can still transfer your house in a trust. You still owe the mortgage. The bank doesn't care as long as you're still getting paid on the mortgage payments. If you have a reverse mortgage, the same thing applies. Okay, you can do the same. Okay, your mortgage is still there; it's still going to be a lien. again, and then if you decided you wanted to sell your house and you put it in a trust, you could still sell it, but like anything else, the mortgage would first have to be paid off. Yeah, you had a question?
No,
Oh, okay.
that was just to follow up, but you already followed up on this question.
Right. So, so it's kind of a no-brainer for most people to at least protect your house by putting your house in a trust. You still have control, you're not losing control of your house. Now, the other question comes about, well, my house is one of my assets, but I have other assets, what do I do with those? When I say other assets, meaning I have money in the bank, I have stocks, whatever. All of what I said about the house applies to that as well. You could take, let's assume you have a house, and you also have a stock portfolio. Well, that stock portfolio could also be transferred into a trust as well. Now, not the disadvantage, but keep in mind, once you do that, you no longer have complete control over that money, which means that even though it's in a trust, you say, okay, I want to sell some stock and I want to spend my money on something else. It's not up to you to then say, okay, I sold my stock for $10,000, my son's the trustee, give me $10,000. He can't give you the $10,000 because you've put it in a trust, and you've said in the trust, when I die, who's going to get the money? However, there are always within a trust of still utilizing some of the income from that portfolio by certain language in a trust, which could say that even though I'm putting this in, I still have the right to get all the dividends, the interest, whatever it might be. So all of these trusts can be tailor-made to however your particular needs are. So, yep.
At what point in the lifespan is it appropriate to start doing this?
There really is no age. I have people that are in their mid-50s that have done it, and obviously later. But I would say, unless someone has a serious health issue, okay, that probably 60 is when people will generally start to. And I'm talking about the trust now. I'm not talking about the basic needs that everybody should have of a power of attorney and the will. In terms of the trust and protecting their assets, I would say then. And the reason why I say not too early is because most people that are younger, you don't want to be tied down by a trust. You may sell your house, you want to buy another house, you may want to move here, you want to move there. But for most people, when they're in their 60s, they're pretty much going to stay where they are. They might sell their house maybe to go to Florida or something like that. So that would be my recommendation.
I was just wondering, if someone is getting up in age and they're living at home and they want to transfer their house into their kid's name to take care of it, and that person's going to stay in the house, but then that person gets worse as time goes on, and maybe they got to go to a nursing home. Are they going to be charged at the nursing home because they own a house, or that they already, any bills that run up in a nursing home? Are they going to say, well, I don't own the house now?
Let me answer your question. First of all, to answer your question, if you took your house, you transferred one of your kids' name, and now the kid has to go into a nursing home, whatever, the answer is unfortunately yes. They would have the right to file a lien against that house because the kid owns it. Now, that brings me back to something else. Sometimes people have come to me and said, you know what, I protected my house, I put it all in my kid's name. That is the absolute worst thing to do. Never, ever, ever put your house in your children's name. There are many reasons. Let me give you some examples. I had a man that came in, he wanted his house in his daughter's name. We did it, and he had a life estate in the deed, which meant that even though it was his name, she couldn't throw him out, he had the right to live there. Little known to him, she had credit card debt beyond belief. She was being sued left and right, and the windup was that all of these people suing her now, since she owned the house, had a judgment, which is now a lien against his house. So he transferred his house to his child. The child ran up all sorts of debt, and now his house that he lives in has judgments against it of, many, many dollars. So it is never a good idea to put it directly in your children's name for that reason. There's no protection. When you put it in a trust, even though one of your children may be the trustee, it doesn't matter what their financial condition is. If one of your children is running up debts left and right, they can't file a lien against the trust because your child doesn't own the trust, the property. You don't own the property. It's owned by the, quote, trust. So it also protects your house from creditors, your creditors as well as the creditors of your children. Sometimes people also think, well, if I just add my daughter's name or my son's name on the deed, somehow I protected it. It doesn't. If you have your name on any asset, Medicaid says, we don't care that your daughter's name's on it and your name, you own it all as far as we're concerned. So it's never a good idea to put children's names on your houses or any other property. The best way of protecting it is putting it in a trust. That way you know that they don't have control over it, you still have control, and they're only gonna receive it when you're gone. So, that answer your question, Tim?
Yeah.
But, if you have income though, it doesn't matter what you do with the house, say you,
Okay, we'll get to the income, okay? Now, let's assume you transferred your house, and now you have to get Medicaid. And Medicaid, let's assume for the sake of argument, says you're only allowed, husband and wife, say $1,500 a month, and your income, your pension is more than $1,500 a month, is $2,000 a month. The extra money, rather than Medicaid getting it, there's a way of putting the extra money into something called a pooled trust, where the money goes into a trust, and you're allowed to draw that money out, the extra money you've put in, let's assume there's an extra $1,000 a month, and use that money to pay your bills. I transfer my house, but I still have to pay the cable bill, the telephone, and everything else. So rather than Medicaid getting it, I could still use that money for these extra items. Okay, that's the way it works with that. Now, the other question sometimes people ask, what about IRAs and pension plans? If you have an IRA or a pension plan, that's exempt from Medicaid. But if you're receiving payments under a pension or an IRA, well, that's considered income. And if it exceeds the amount, rather than Medicaid getting it, if you deposit that in something called a pooled trust, and that's a trust, special trust run by the government, which allows you to deposit the extra money into it, and then withdraw on it monthly or however you need it to use, that's permitted as well. And usually, it's not a matter of making up bills. Most of the time, the extra money is probably what you do need to run your house. You're still gonna have to pay your utilities, your real estate taxes, all of the normal living expenses, food, clothing. So that's how the extra income problem is circumvented. So,
That was the question I had.
yeah. I tried to keep it general, but, you know, we get into specifics. So if you have any other specifics, you know, let me know, I'll be glad to. Yeah,
If I put my house in a trust,
yeah,
now I have a pension, I get the social security.
right.
So I wind up in a nursing home, well, they'll get my pension and social security. The nursing home, right?
No, your pension and you're talking about if you wind up in a nursing home,
Right,
then they will. You're only allowed to keep, that's right.
they can have it.
Yeah, that's
Really?
right. There
As
is
long
no
as they
way
don't get
around
the
it,
house, I
because
don't get
the
it.
example I gave you before is what's called a pooled trust,
Right.
because you're still living in the house and you have expenses, but technically you're in a nursing home, you don't really have any expenses. Now, another thing is sometimes people say they didn't make any plans at all, and now all of a sudden, the husband or the wife has to go into a nursing home, and they haven't done anything. Is there a way around that and saving money? And the answer is yes, there is a way. And one of the ways around that is this 5-year look back that I mentioned to you. One of the exceptions is transfers between a husband and a wife. So if the husband has to go into a nursing home and the wife has a power of attorney, she could take all of his property and transfer it to herself in her name. So now, there's no 5-year look backs between husbands and wives. That will enable her to protect whatever property they have. But of course, the problem now is everything is now in her name. And if anything happens to her, it's going to go. Now, she could do the same thing, but then we start a whole new 5-year look back for her. And generally, when this happens, you know, they're usually close in age, the husband and wife. But there are ways, even aside from that, if someone has to go into a nursing home, of still saving a lot of their property. When I say a lot, I don't want to go through how it's done, but you might still be able to save almost half of all your property. I'm talking about the person has to go into a nursing home tomorrow and nothing's been done. So there are still ways around that. It's kind of technical and I'm not going to go through that right now. But I think the most important thing is, as a minimum, for people to protect your house. Forget many times, and it's totally understandable, you don't want to give up control of your bank accounts, your stocks, or everything else. But if you live in your house, and you know, realistically, I don't intend to move anywhere, okay? There's no harm in transferring it into a trust. You still have a life estate, you still have control. Even though your children are named as beneficiaries, you've got the right to change that. The trustee is usually one of your children, so if you tell your trustee, if you want to sell the house, I want to sell my house, now, you're gonna have to sign, since you still have ownership, so will the trustee. People say, well, what happens if my son says, and I had this happen, he didn't want to sign it because the father wanted to move somewhere else, and the remedy was simple. We're changing the beneficiary of the trust, so you're no longer the trustee, we got a new beneficiary, so you get nothing. Keep in mind, even though you can't take it back, you could change who the trustee is. And that's exactly what this man did. It's a real story. They didn't want him to sell the house, and they didn't want him moving somewhere else, and that's what he did. I'll never forget it. His son then says, no, it's okay. And the father's a real old says, no, it's over. And that was it. So you still have control. It's not that you're giving everything up. You still have control. So that's kind of a no-brainer. The other area, when you talk about putting your stocks, bonds, and cash into a trust, then it gets a little trickier. And I usually advise people not to do that initially. You can always, as things develop, handle that when you get closer to having a problem. But that's why the business of power of attorney, durable power of attorneys, plays into this. Because if you haven't made plans, and all of a sudden you have a stroke and you can't even sign your name, no one could do any of this. They need someone who's authorized legally to sign your name. So that's why the durable power of attorney. And the question is, why do they call it durable? Sometimes I'm asked that. Originally, powers of attorney did exactly what I said. But if you became legally incompetent, you had a stroke, well, then the power of attorney was no good anymore. So they changed the law and they said from now on, you could have a power of attorney that's durable, meaning as long as you're alive, the power is good forever. So that's why the term durable power of attorney comes in. Anything else? Yeah, yes.
Just with regard to the $1,500 threshold for Medicare, do they differentiate between, say, an old pension and a disability pension? Or is it all
No,
just?
they don't care whatever income you
Okay.
have. They don't care whether it's from Social Security or private pension. It makes no difference. No, they don't differentiate that. Now, there are other ways besides this pooled trust of preserving the extra income that we talked about, but it's kind of technical and there'd be no point. I'd be glad to discuss it. There's other ways of keeping that extra income. All right, anything else? Well, listen, after we finish, any questions that come to mind to anyone, if you want to call me up, you all have my card. If you want to come in, there's no charge. I'll be glad to sit down with you and discuss whatever it is. And, or if you want to discuss it with your own lawyers and tell them what you heard, and go ahead. But I think it's important that everybody have some basic plan, because without this, unfortunately, things may not turn out the way, you want them to turn out. It's a morbid subject, but unfortunately something that's got to be addressed. And all of us have probably seen situations where people didn't do anything and the consequences that happened, whether it was they lost their house or they wound up on life support for months and months, or things like that. So that's it. Well, listen, I thank you all for inviting me here. And
Thank you.
Thank you.
Thanks, this was great.
Very enlightening.
It really was.
We'll make it a point.
Oh, you want to name me your trustee yet?
Yeah.
you can name anyone over 18 as your trustee.
Oh, that lets me out.
Oh, you're welcome. You're welcome.